Okay, I'm reading about mutual holding companies out of the Reference Guide to Regulatory Compliance on paper, page 678 of the old text. Mutual savings associations and mutual savings banks date back to 1819 and were established for the purpose of providing funds for thrift and to enable their members to build and purchase homes. Federal mutual associations have many of the attributes of ownership for their depositors. However, for those that use the incorporator model, depositors do not have ownership attributes. Federal mutual savings associations were regulated by the Office of Thrift Supervision until July 2011, when supervisory authority was transferred to the Office of the Comptroller of the Currency. State chartered mutual savings associations and banks are regulated by their state banking regulators and either the FDIC or the Board of Governors of the Federal Reserve System, Federal Reserve Board, or FRB, depending on membership in the Federal Reserve System. The Competitive Equality Banking Act of 1987 provided for the formation of mutual holding companies on the federal level to form entities that hold stock and savings associations as well as related companies. This section addresses the formation of federal mutual holding companies. State law governs the creation of state chartered mutual holding companies. And effective July 21st, of 2011, the Dodd-Frank Wall Street Reform and Consumer Protection Act transferred the authority for mutual holding company supervision from the OTS to the Federal Reserve Board. The Federal Reserve Board issued Regulation MM as an interim final in September 2011, subject to comment. The final rule, taking into account the comments, has not been issued. Coverage. Savings associations that apply to be reorganized and become a mutual holding company and the resulting stock issuances. Acquiree institutions that are acquired by mutual holding companies that were mutual organizations prior to the acquisition. Also covered are federal mutual holding companies that are formed under the Savings and Loan Holding Company Act with the approval of the FRB, subsidiary holding companies owned by mutual holding companies, and members of mutual holding companies are the depositors and borrowers that are entitled by the charter to vote on matters affecting the company. The requirements under mutual holding company rules. Formation of mutual holding companies through reorganization. Letter A. Number 1. Mutual savings associations that reorganize to become mutual holding companies must develop reorganization plans approved by the associations and the acquiree's board of directors. 2. File a reorganization notice with the FRB and receive all necessary regulatory approvals, including fulfilling all conditions imposed by the FRB. And C. Obtain the approval of a majority of the total votes of members of the reorganizing association and acquiree association. And the reorganization notice goes to the Fed because we're discussing formation of mutual holding companies, and this is applying to mutual savings associations that reorganize to become mutual holding companies. FRB disapproval. The FRB may disapprove a proposed reorganization plan if it is necessary to prevent unsafe or unsound practices. The financial or managerial resources of the organization warrant disapproval. The proposed reorganization would violate any law, or the proposed stock issuance fails to meet the standards required by Regulation MM. The failure to submit a business plan in connection with the reorganization notice. The business plan contains activities inconsistent with the credit and lending needs of the proposed market area, or the business plan fails to demonstrate that capital will be deployed in a safe and sound manner. C, the acquirer does not have necessary managerial resources for the reorganization. I, criminal, civil, or administrative judgments, consents, or orders, indictments, formal investigations, examinations, or civil or administrative proceedings resulting in orders issued against the acquirer by any federal or state court or agency during the previous 10 years. Fraud, moral turpitude, dishonesty, breach of trust or fiduciary duties, organized crime or racketeering, violation of securities or commodities laws, violation of depository institution laws or regulations, violation of housing authority laws or regulations, or violations of the rules or of a self-regulatory trade or professional organization. Roman numeral 2, under a lack of managerial resources, is the denial or withdrawal after the receipt of a notice of an intent to deny by the acquirer of any application relating to the organization of a financial institution, an application to acquire any financial institution or holding company, a notice relating to a charge and control related to any application, and an application or notice under a state holding company or change in control statute. And during the previous 10 years, either the acquirer or an affiliate were placed in receivership. Roman numeral 4, under a lack of managerial resources for the reorganization, is during the previous 10 years, any management official of the acquirer was a management official or director other than an official or director serving at the request of a federal banking agency or controlling shareholder of a company or savings association that was placed into receivership, a management co-assignment program, or was liquidated. There has been a felony of the acquirer, an affiliate, or a management official of either, knowingly making any false statement to the OTS in connection with an application, notice, or other filing, or acquiring at the time of submission of an application or notice of stock in the Savings Association by the acquirer in violation of OTS's regulation associations. And D, the proposed capital plan is not sufficient. E, the proposed stock issuance fails to meet OTS standards. Or F, the reorganizing association or any acquirer association fails to furnish required information. Number 3 discusses the capital requirements. So these are all requirements under A, forming a mutual holding company through reorganization. The capital requirements part explains reorganization plans will be disapproved if the resulting organization or any acquiree would be considered inadequately capitalized by the Fed. And number 4, failure of the FRB to act on a notice. Reorganization may occur because the FRB does not disapprove within 91 days, but will be subject to the following conditions. A through D. A, it must be consummated within 1 year. B, the mutual holding company may not be capitalized in an amount greater than that permitted by the regulation. C, no request for regulatory waivers or forbearances will be deemed to be granted. And D, the following information must be timely submitted. Roman numeral 1 through 4. 1 business day prior to the reorganization, the CFO of the organizing association and any acquiree association must certify to the FRB that no material adverse events or material adverse changes have occurred with respect to the financial condition or operation of the association. No later than 30 days after the reorganization, the holding company must file with the FRB a legal counsel certification stating the effective date of the reorganization, the number of shares of stock held by the resulting association and any acquiree association and by any other persons, and that the reorganization has been consummated in accordance with the applicable laws and regulations. Three, No later than 30 days after the reorganization, the holding company must file with the FRB an opinion of its independent auditor certifying that the organization was consummated in accordance with GAAP. And 4, no later than 30 days after the reorganization, the holding company must file with the FRB a certification that the holding company and its subsidiaries will not deviate materially from the approved business plan. Rights of the members, letter B. Rights of members of mutual companies. Number 1, the charter of the mutual holding companies must, A through D, confer upon depositors of the resulting association the same membership rights in the holding company as depositors had in the reorganizing association immediately prior to the reorganization. B, confer upon depositors in any acquiree association the same membership rights in the holding company as depositors had in the acquired association immediately prior to the acquisition. C, confer upon the borrowers of the resulting association the same membership rights in the mutual holding company as they had immediately prior to reorganization. However, it must not confer any membership rights in connection with any borrowings made after the reorganization. And D, confer upon the borrowers of any acquiree association or any mutual association who are borrowers at the time of the acquisition the same membership rights in the holding company as were conferred upon them by the charter of the acquired association immediately prior to acquisition. However, it must not confer any membership rights in connection with any borrowings made after the acquisition. If the acquired association is merged into another association from which the mutual holding company draws members, the borrowers of the acquired association must instead receive the same grandfathered membership rights of its borrowers of the association into which it is merged received at the time that association became a subsidiary. And 2, rights of depositors and borrowers of stock associations. When a mutual holding company acquires a savings association in the stock form, it may not confer any membership rights upon the depositors and borrowers of the association unless the association is merged into an association from which the mutual holding company draws members. In that case, the depositors of the stock association shall receive the same membership rights as other depositors of the association into which the stock association is merged. Contents of a reorganization plan, subpart C. Oh my God. Reorganization plans must contain a complete description of all significant terms of the proposed reorganization, including attaching any stock issuance plan that is proposed. Reorganization plans must also provide that the charter and bylaws of the reorganizing association will be amended to be in the form of a mutual holding company. B, for the organization of the resulting association, either in an interim federal or state savings association subsidiary of the reorganizing association. That if the reorganizing association proposes to form a subsidiary holding company, it must provide for the organization of a subsidiary holding company. D, that the charter and bylaws of the acquiree association be amended to make the form of the charter and bylaws of the savings association to be in the stock form. And E, that upon consummation of the reorganization, substantially all of the assets and liabilities of the reorganizing association be transferred to the resulting association. F, that all assets and liabilities of the reorganizing association that are not expressly retained by the holding company will be deemed transferred to the resulting association. Further contents of the reorganization plan is G, that each depositor in the reorganizing association will, upon consummation of the reorganization, receive without payment an identical account in the resulting association. H, that the reorganization plan as adopted may be substantially amended as a result of regulatory comment before the solicitation of proxies from the members to vote on the reorganization plan and at any time thereafter with the concurrence of the FRB. That the reorganization may be terminated by the board of directors of either the reorganizing association or any acquiree association at any time prior to the meeting of the members of the association called to consider the reorganization plan and at any time thereafter with the concurrence of the FRB. J, provide that the reorganization plan will be terminated if not completed within a specified period of time, not more than 24 months from the date of the plan approval, and may not be extended by the reorganizing or acquiree association. And K, lastly, provide that the expenses incurred in connection with the reorganization will be reasonable. D, letter D, Savings Association subsidiaries issuance of stock.